Now to today's program. The Program Committee of City Club brings us another essential community issue today to consider: juvenile crime. Those of you who have read your club bulletin noted that the U.S. statistics show the crime rate for kids aged 12 to 15 has risen 36% in the past 2 decades and up 27% for ages of youth aged 16 to 19. But the increase in rates is much sharper in Multnomah County. Total juvenile delinquency cases rose 69% since 1988, totaling more than 9,000 charges filed last year. The most rapidly rising element in this group is for violent offenses, including assault and murder, which is up 125% in the past 5 years. Meanwhile, as we're likely to hear today, the ability of the system in this county to treat these cases is actually declining in a number of respects. Just one aspect being the number of beds available for close custody, down by 1/3 since 1985. The headline-grabbing crimes associated with teenage crimes too frequently occur in Portland, but are not limited to the core area of the region. A demonstration just this past week of parents at a Hillsborough junior high school was mounted in response to an attack on 2 students allegedly stabbed by gang affiliates in that community. With us to explore this serious community concern is a panel of experts in the local juvenile justice system. Judge Elizabeth Welch is the Chief Family Court Judge for Multnomah County and a member of the Circuit Court. She has served as a family court judge for 5 years and is a member also of the Juvenile Corrections Council. Earlier in her career, Judge Welch served as Multnomah County Deputy District Attorney, specializing in child abuse and in termination of parental right cases. A graduate of the University of Chicago Law School, Judge Welch has also served in the past as the city's director of the Office of Justice Programs. Mark McDonnell is Senior Deputy District Attorney, Multnomah County. Mark is sitting to my far right. He's in charge of the juvenile unit. He has served on the Multnomah County Youth Action Plan Task Force and is a member of the Juvenile Corrections Council. Mark came to Multnomah County after experience in the district attorney offices in Marion County and Douglas counties. He received his law degree from the University of Oregon. Mark will speak to the younger kids in the juvenile court system. This is where he believes the system must concentrate its limited resources if there's to be any hope for reducing the overall rate of juvenile crime. Timothy Travis is staff attorney for the Juvenile Rights Project, a nonprofit law firm that represents abused, neglected, and delinquent children in Multnomah County Juvenile Court. His program also serves class action litigation on behalf of children. Timothy has lobbied on behalf of children at the state legislature. His focus today will be on meeting the rehabilitation needs of delinquent children as a basic approach to improving public safety in the community. Timothy has been a lawyer for children for 8 years. He previously was a high school teacher, counselor, and coach. He also holds his law degree from the University of Oregon. Judge Welch will begin the presentation today, followed by Mr. McDonnell and then Mr. Travis. Please join me in welcoming this knowledgeable trio of juvenile justice specialists to the Portland City Club.
Thank you, Don. And good afternoon. I think I've crossed some kind of a barrier here. Nobody says when I graduated anymore. I think they know it's no longer couth. Yesterday, the IRA claimed responsibility for lobbing bombs at Heathrow Airport. The use of violence in the solution of interpersonal and political problems, the glamorizing of violence, the strutting macho role models that pervade the media, pervade the lives of our children. The problem that you heard about described in these statistics does not come out of nowhere. It comes from the society in which our children are growing. In Multnomah County, The court issues an average of 300 Family Abuse Prevention Act orders every month. What's that mean? That means that in 300 families, there is enough of a crisis every single month for a member of that family to go to the courthouse, fill out papers, and ask for an order that restrains contact between that person and another member of their family. And recently in court, a psychologist testified that our society is awash in drugs and alcohol. Great line. Our society is awash in drugs and alcohol. And so we have violent children in unprecedented numbers to deal with in the court system. As we undertake still another re-examination of the criminal justice system and the juvenile justice system, as is expected in the upcoming session of the legislature, I think it's important to start out remembering that the United States has the highest incarceration rate in the Western world, and that we also have the highest crime rate in the Western world. The juvenile justice system, in my opinion, exists historically and hopefully continues to exist as a statement by our society of how we feel about our children. That we recognize that the condition of being a child is a condition of vulnerability, and that we have an obligation to protect them from abuse and neglect and from their poor choices as they grow to adulthood. The juvenile court movement arose in Chicago just about 100 years ago in the United States to prevent children from being jailed with adults and to acknowledge the reality that children are different from adults. How are they different in this context? They are susceptible to both good and bad influences, and with proper intervention, misconduct can be arrested for some children. For the 25 years that I have been involved in the juvenile justice system, the primary complaint has been what it is today, from the beginning to this moment. The system is too lenient, it doesn't work, it doesn't fix the kids. The problem in the system, and I think Mr. Travis is going to talk more extensively about this, and I'm going to just hit on it, is that we need to treat children sooner. We need to intervene sooner. We need to intervene more effectively. Our resources at this point are at an all-time low in that 25 years. In the last 10 years, there has been a drastic drop-off in the resources available to the juvenile justice system, and at least a correlative increase in the resources available to adult corrections. Public concerns are fear, terror, and wanting something to be done. What I'd like to talk about in the rest of my whatever minutes is the heart of the discussion that's going on now about changing the juvenile justice system, and that is what we used to call remand and is now properly called waiver. Most of us haven't trained our mouths yet, and we still say remand. Most of you will know better what I'm talking about by using the old incorrect term. I suspect every legislature in the United States is dealing with this issue or already has. This is not unique to our community or to our state. And in a concern or in a panic over what is going on, there are proposals made that a larger portion of the adolescent population involved in the commission of crime be treated as adults. The present system operates on a statute which says that there's to be a hearing when the district attorney or the juvenile department asks that a court consider sending a juvenile to the adult system. They have to be 16 unless the charge is murder, in which case it can be 15 for this even to be considered. And the statute sets forth a number of considerations that the court is to take a look at in deciding whether or not a child should be remanded to the adult court to be tried on the charge in the adult court and to be dealt with by adult correctional facilities. The decision, of course, is the judge's to make, and that decision boils, in my experience, down to the following. I'm supposed to try to figure out based on the testimony of people who have worked with this child, juvenile court counselors, McLaren counselors, depending on what programs the child's been in, whether or not this child can benefit from the resources in the juvenile system or not. Now, the reason this is such a critical consideration, and the main point I hope I can leave with you today, is that the treatment available in the adult court is so minimal and is totally voluntary that there is no basis on which to assume that a person sent into the adult system is in fact going to get treated. They're going to be housed, and they will get treatment if they ask for it, and if the waiting list for that particular kind of treatment is not too long. And of course, as everyone knows who's ever been in any kind of treatment or who provides treatment or who's tried it, it takes tenacity, and a young adult or a still adolescent child maintaining a commitment to treatment in a correctional system is somewhat difficult for some of us to picture. So there is a ultimate fallacy involved in talking about remand, and that fallacy is that the public is better served by children being dealt with in the adult system. Why is that? Why is that the assumption that people make? It is a more punitive system, I think is the implication. They will stay in prison longer than they will stay in custody if they are treated in a juvenile facility. The statistics don't bear this out. It does in some very serious crimes, of course. The question becomes ultimately whether we want to continue to work to help these kids, to treat these kids, or whether we feel that their behavior is so outrageous or uncontrollable or dangerous that we want to send them to the adult system where they will be incarcerated, but they will leave incarceration in vast numbers without ever having received any significant treatment. And then they will be back in the community to be dealt with again. The options that are being considered to the present system on remand are automatic remand on children who've committed certain offenses. Say, for instance, the proposal made by the District Attorneys Association both last session and I understand perhaps again this coming session of the legislature, that children who have been charged with murder, attempted murder, Mr. McDonnell will be a better source than I on exactly the list, all very serious crimes, robbery in the first degree, rape with force, sex abuse with force, would all automatically go to the adult system to be dealt with if they were over the age of 16. Juvenile justice system is based on the concept of individualized justice, individualized treatment, to look at a child only in terms of the behavior that brings the child before the court is contrary to the whole concept of the juvenile justice system. However, this is a, quote, solution that has a lot of attraction because it is simple, it's clear, and it has a certain fairness involved in it in that all kids charged with the same crimes are treated the same way. The second alternative is something that's been around in many states for a long time, and that is basically that the decision is not made by the court but by the prosecutor. It's a prosecutor's option where the child is charged if they're over a certain age and the crimes are the same basic outline that I gave you before, very serious offenses. But I want to talk just a minute about the third option, which I think is a very interesting one. Unfortunately, has to be referred to as the Texas plan. The Texas plan is actually an operating system in the state of Texas, and what they've done is that they have abolished remand. Nobody gets remanded to adult court. All children are dealt with in the juvenile system if they have committed certain offenses, and we'll assume for the sake of discussion that it's that same list of very serious felony charges. They will be offered the opportunity to have a jury trial, which in 1990s is really the only difference procedurally between the juvenile system and the adult system. So they will have the opportunity to have a jury trial in juvenile court. If they are found to have committed the offense, they will be sentenced, and that sentence will be by statute, by the adult statute, so that, for instance, a child found guilty at 16 of armed robbery could be sentenced to 15 years. I don't know what the sentences are. I don't deal with the adult criminal system, but for a very lengthy sentence, it's obviously far beyond the amount of time that a juvenile facility would be working with a child, because at 21, at the absolute outside, the child would no longer be in a juvenile facility. And at some point down the road, age 18, age 19, there would be an option of the legislature could exercise. the system would then look at this child and see how they have fared in the treatment process. Because that's really when a judge hears a remand now, what they're trying to figure out. Does this child have the background, the attitude, the treatment history, just a whole variety of issues that will make him or her amenable to treatment that will make him or her no longer dangerous to the community. So rather than guessing in advance, the issue would be assessed at that critical point about age 18 or 19 when, if the child had not responded to services, they would simply be transferred to the adult system to serve out the balance of their sentence. And if they had indeed responded properly, and as one would hope, they would then be treated as if the old system would have treated them, and they would be released from custody or to a lesser level of custody. I'm going to stop now by saying that if you don't like the juvenile justice system, to quote my colleague Steve Harrell, you'll hate the adult court system. And what I mean by that is any notion that there is long-term protection to the community offered by sending a child to the penitentiary, and also the assumption that children dealt with in adult court will be treated as serious offenders. One of the things that national statistics show is that children entering into the adult prosecution process are treated as first offenders, are often released when they would have been held in juvenile facilities awaiting trial, and receive probationary sentences when they would have received placement in state training schools in the juvenile system. Good afternoon.
Thank you. First of all, I want to thank you for the opportunity to come here and speak to you today. Problem of juvenile crime is a very serious problem, and it's a problem that's growing not only in Portland, but throughout Oregon and across the nation. I won't go over the statistics that were mentioned earlier, because we've all heard those before, and they're all quite remarkable. But I'd like to point out that this state went through a process approximately 10 years ago where it decided that it wanted to treat offenders in the community rather than in a juvenile corrections system. That occurred in 1985 and was called downsizing. And that did not happen only in Oregon, but it was a trend that happened throughout the community, throughout the country, and was based upon the philosophy that delinquent youth can be better served in their own communities. Prior to 1985, we had approximately 750 secure beds in the state juvenile corrections system. Today, we have a third less than that at 513. No matter how serious the offender is, the state is not allowed to go over that number. In exchange for handling these offenders in the community, our local juvenile departments were given funds to run local treatment programs. Unfortunately, the experiment has not worked in Oregon, and it has not worked across the country. There has been devastating effects. Our juvenile training schools are above capacity. I was speaking to the assistant director of McLaren today, and they are 36 over cap. They have to make a decision within the next 2 or 3 days of which 36 offenders have to be released back to the community. And they freely admit that they are making those decisions not based upon treatment needs or upon that individual's readiness to return to the community, but simply because of population control. That's very chilling when we especially consider the fact that the population of the training schools have changed from what were primarily property offenders before downsizing occurred to primarily person-to-person felons. Because of that overcrowding, the sentences that people serve in the training schools have also been dramatically reduced. The average time for an individual convicted of aggravated assault or armed robbery is only 3 or 4 months. And it's hardly amount of time that the juvenile authorities will have to try to make a difference with these individuals. And all too often, they're simply sent to back to their own communities without their problems being addressed. Not only are property offenders not being sent to the training schools, but truly violent individuals. I brought a lot of diagrams and overlays for you to see, but I don't think there'll be enough time to use them. But I want to give you a couple examples of individuals that we have prosecuted on our court and have tried to commit to the training school but have been unable to do so. One was a young man who had approximately 10 referrals to the juvenile department, but was involved in a drive-by shooting in which he fired 3 rounds into a crowd of 15 youth while they're standing on a porch. Luckily, he only hit 2 of them, one in the arm and one in the hand. We tried to remand that individual to adult court because of his prior history and because of the seriousness of the offense, but we were told that we could not do so because he had not had the availability of all the services of the juvenile system, meaning he hadn't been committed to the training school in the past. We then tried him in juvenile court. We convicted him of 2 counts of attempted murder, 2 counts of assault in the first degree. But when we came to the time of sentencing, the juvenile department recommended, and the court followed, that he be continued on probation because there was more serious individuals in the training school that would be released if this individual were committed. Other examples are prevalent. One of the young men that were involved in the beating of Tim Hawley at the Lloyd Center was on probation for rape and unauthorized use of a motor vehicle. And the rape involved the rape of a 4-year-old girl. And he was out in the community based upon the condition that he enter a sex offender treatment program. But because of waiting lists to get into that program, and the fact that when an opening came up for him, he didn't show up, he did not attend a single treatment session between the time of his conviction and the time of the assault on Mr. Hawley. You might recall the incident of a young man who forced his way onto a TriMet bus to shoot a rival gang member in our community this fall. He missed the rival gang member, but he wounded 2 young girls sitting in the back of the bus. That young man had been convicted of robbery in the first degree less than 9 months prior to that, in which he and 2 other juveniles robbed a man at an automatic teller machine at gunpoint. He held the gun to the man while the other 2 companions slugged him in the face and demanded that he take all his money out of his account. And when the victim tried to get his license number as they sped away, this young man fired 3 times at the victim. Those are the type of individuals that we are unable to commit to the training school because there's not enough space or resources. What does that mean? That means our local juvenile authorities are forced to handle more and more dangerous, incorrigible individuals in the community. Those individuals are put in treatment programs that were not designed for individuals such as them, and are thus forcing other young people who could benefit from those programs out of those programs without any resources. The true tragedy, though, is that many young people who commit less serious offenses, who are coming into the system at the beginning, are being ignored by the juvenile justice system. Until just recently, when the District Attorneys Association obtained the power for district attorneys to initiate delinquency petitions, it was not at all unusual in this county for young people to be arrested 6 or 7 times before ever being formally charged. It was common that they would be diverted to a youth service center, supposedly for counseling and community service, but it was not all unusual for those individuals not to even show up to those programs, let alone successfully complete them, before they're arrested again and diverted to these programs time and time again. The District Attorney's Office and the Oregon District Attorneys Association believes that the resources and the focus of the juvenile justice system should be returned to those young offenders coming into the system for the first time. That is the only chance that we have to turn around the increasing crime rate of juvenile crime. That if we wait until they're ingrained in a criminal lifestyle, it will be too late. Unfortunately, the reality is that there is no new money to do that. This state faces a $1.1 billion general fund shortfall in the next biennium. The reality is we will be lucky to have the resources that we currently have in the coming years. So we must make a difficult decision where we're going to spend our dollars. Are we going to spend it to try to save violent repeat offenders? Or are we going to spend our money to try to turn around young people the first time that they come in contact with law enforcement authorities? We must face that decision, because by not facing that decision, the fact is that the young people who we have the best chance of turning around and intervening in their lives of crime will go untreated. Thank you.
I'd like to start by expressing my thanks for that generous introduction. I have never been referred to before as an expert. It's sort of thrilling. I also remember my father used to say that many people I called experts were called crackpots, so we'll see what happens. In the brief time that I have today, I'd like to address 4 points. The first is that juvenile crime has causes, and that if we don't deal with the causes, we're not going to deal with the crime. The second is that community protection is the highest value in the juvenile system, or should be the highest value in the juvenile system. The third is that rehabilitation of offenders is the best way to affect community protection. And the fourth is that individual assessment of offenders is necessary in order to affect their rehabilitation. Let me start by saying I'm not in favor of crime, okay? I have a house, I have a family, I have a car. I don't want to be a victim any more than Mr. McDonnell wants to be a victim. And I know how bad it is out there because I represent these kids. I sit at council table next to the kids that Mr. McDonnell is talking about. I deal with them in probably more depth than Mr. McDonnell does, so I truly appreciate where these kids are coming from. My first point is that juvenile crime has its causes and we have to deal with the causes. There was not a kids' summit 10 years ago somewhere in the United States where the children of America decided that they were going to escalate their violent behavior on the rest of us. And violent children were not dropped by UFOs, okay? As the judge said, kids have escalated because our society has escalated around them. Think about the decade of the 80s and what's happened. We've had a shrinking middle class, we've had increased poverty. We've had continued high divorce rate, continued high dysfunction rate. Judge Welch is right. Alcohol and drugs. If you would do away with alcohol and drugs somehow, tomorrow, Mr. McDonnell and I would be out of jobs. That's how serious that is as a contributing factor. Teen mothers are increasing. We're beginning to see even more. Most people in prison are the children of mothers who had their first child during their teenage years. Teen mothers. And of course, absent fathers. Fathers have to be on the scene. Weapons, gangs, crack cocaine. Those are new things in the 1980s, this proliferation. The family and the other support systems for children in our society have eroded during the 1980s. Social commitment to children has eroded during the 1980s. The state of Oregon today spends the same number of dollars adjusted for inflation on children in trouble that was spent in 1981. Let me say that again. The same number of inflation-adjusted dollars go to troubled kids in Oregon as we spent in 1981. Think of everything that's happened since 1981. We have more kids, for one thing. From this, I do not conclude that we need to attack all of these social problems and just let these kids go. We do need to deal with these children. But attacking the social problems is the best solution, long run. In fact, it's the only solution, long run. We have to work too, though, with the kids who are with us now. Community protection is supposed to be, should be, the #1 value of the juvenile court system. Let me tell you a story about a serious gang kid. Mr. McDonnell can talk about serious gang kids, I can too. I represented this child. He was a Vietnamese child, came over from Vietnam. His family had been decimated there, arrived on our shores, totally traumatized and dysfunctional little kid, grew up to be a member of a Vietnamese gang, an Asian gang called the Red Cobras. I represented this child numerous times on numerous charges, escalating seriousness. He was on probation. He was in and out of the treatment programs that Mr. McDonnell talked about. And finally, he saw the light, and he rehabilitated on the probation system. I hadn't heard from him in 9 months. After he was a good customer, he was with me frequently. But after 9 months, I hadn't heard from him, and all of a sudden, I got a police report and a new petition on a very serious robbery charge. It was alleged that he and some gang members had stuck up a birthday party, had broken in and taken everyone's watches and money, and I thought, oh man, I thought. Then I looked at the date on the police report. This crime had predated his rehabilitation. In other words, they had just found out that he'd been involved in that. This crime was a year old. What was the outcome? He got off scot-free. We went to the judge. He pled guilty. He was given a suspended sentence, and it was suspended based on his continued good behavior and rehabilitation. There are people who will tell you that that was a miscarriage of justice, that he should have served time because it was a serious crime and a gun was used. And I'm here to tell you that was the right outcome because the community was protected by that outcome. If he'd been sent to jail, to the training school, or taken to the adult system, what good would have been served to anybody by that? He is a productive member of society. We're safe from him. Rehabilitation of offenders is what we should be looking at. That's the best means of attaining community protection. We know, by the way, that rehabilitation works, okay? When the resources are put there, when the resources are followed up, when you actually put rehabilitation into place seriously and work with it, it works. We know that punishment by itself doesn't work. And if you doubt that, take a look at the adult system. Why in the world are we trying to make the juvenile system more like the adult system? The adult system is not a success at protecting us from crime. There are people in the drumbeat in the press, in the letters to the editor, in the op-ed, and what it comes down to is we got to crack down on these kids. What it comes down to is we have to hurt these children until they behave themselves, and we just have to keep hurting them and hurting them and hurting them. Let me tell you, I represent abused and neglected children as well as delinquents. And you know what? They're the same kids. Many of these children have been so badly hurt in their life, you can't hurt them enough to make them behave themselves. Me, you can hurt me and make me behave myself because I got a house and a wife and a family, and man, I don't want to lose that stuff. But I'm not a kid who's been abused and neglected, knocked around by the system, parentless, etc. Some kids are out there who've just been hurt that much. Punishment alone doesn't work, but rehabilitation does, and it's not 100%. It won't work 100% of the time, but it's our best bet. Mr. McDonnell talked about waiting lists, and you're right. There are long waiting lists for treatment. A year and a half ago, there were 251 children on a waiting list for serious residential treatment. You know, 2 of those children committed murder. And that's our responsibility because as taxpayers, there was a waiting list for treatment. There's still a waiting list for treatment. It's that long. Mr. McDonnell talked about the failure of the downsizing experiment. And let me say, we're responsible. My law firm is responsible for the downsizing because we sued McLaren over the conditions of McLaren during the early 80s. I wasn't there, but the lawyers who were there then did it. And that cap is there because we put it there. And we put it there, the state of Oregon put it there with us on the end of a consent decree because the state of Oregon is not willing to put up the bucks to put children into secure treatment that's humane. When you're ready to put up the bucks to put children into secure treatment that's humane, then the cap will go away, but not until. I can get worked up when I talk about this. Let's talk about crackdown jurisdictions. You know, many jurisdictions, many states in this country have cracked down on juvenile crime in the way that Mr. McDonnell argues we should do. You know what? Their juvenile crime situation is not a bit better today than it was before they cracked down. In fact, their rates have continued to escalate unabated. Department of Justice statistics. Individual assessment of offenders is what's important in determining how we're going to rehabilitate people. Think about this. A 12-year-old child takes out a knife and he takes money from peers at school. Think about a 25-year-old man who pulls out a gun in the bank teller machine and robs you. And think about a 17-year-old child who beats up a school peer to take his starter jacket. Same crime, robbery in the first degree. Same response for all three people? Well, I don't think so. I think that 25-year-old is probably, maybe, so far down the line that we're going to have to disable him. We're going to have to lock him up. I still think we ought to work to rehabilitate him because I think we all know the statistics say that people engaged in this kind of behavior sort of outgrow it by the time they get somewhere between 40 and 50. I think rehabilitation would help them get there sooner. The 12-year-old, yes, we have to intervene with that 12-year-old. Absolutely. We need the resources. Mr. McDonnell talks about people being referred to youth service centers and there's no follow-up and like that. It's not because the people who are working with these kids are sitting around drinking coffee. It's because there's not enough of them working with the kids. There's not enough juvenile court counselors to follow up on those people who are referred to the youth service centers to make them do what they're supposed to do. When you are ready to fund that intervention, then that intervention will do what it is supposed to do. And I don't mean you, I mean we. When we are ready to pay the price for community safety, then we're going to get it. The 17-year-old child is in the middle between the 12 and the 25. Is the 17-year-old more like the 12 or more like the 25? It's an individual decision. If you take that 17-year-old and throw him or her into prison, I guarantee you he or she is going to become the 25-year-old. We need to know the differences between these children when we make our decision about what to do with them. I think what Judge Welch talked about in terms of a Texas plan, this is the emerging consensus. I think this is what our solution in Oregon is going to look like. We're going to make the decision about whether or not to keep children in treatment at a time after they've been in treatment long enough for us to be able to make an intelligent decision about how they will do, instead of the way we do today, which is sort of stick a finger in our eye and guess, battle of the experts. In conclusion, every single problem has a solution which is simple, obvious, and wrong. I wish I'd made that up, but everybody here knows that that's H.L. Mencken. And locking children up, cracking down, getting tough on kids, it's simple, but it's wrong. Looking like adult criminals, kids who do things like adult criminals, treating them like adult criminals is only going to turn them into adult criminals. Punishing them may make us feel good. We're horrified when we hear about the things that Mr. McDonnell talks about. It's horrible, and it makes us want to just respond. But let's go for more than a release here, folks. Let's go for more than making ourselves feel better, because punishing kids is not going to make us any safer. In fact, in the long run, it's only going to make us less safe. Thank you very much.
Thank you, panel members. Now, as you know, it's time for questions from the floor. The microphone here in the center of the room. Let me remind you when you approach the microphone to give your name and affirm your membership in the City Club. Please let me discourage you from delivery of white papers or advocacy positions, but rather get to the question mark as efficiently as possible. We had 3 members of the club's youth forum here last week who probably asked the 3 best questions and got there very quickly, so it can be done, and I'm sure you'll be happy to join in that model. The panel will answer questions from the head table, so you can direct your questions to an individual member or to all of the members as you will. Ann Jarvis has the first question.
I'm interested in your comments about early intervention. How can we ensure that young first-time offenders get appropriate early intervention treatment? In addition, could you comment on ways that the public schools might cooperate with local government to provide early intervention treatment for at-risk youth?
Go ahead.
I think, in a way, Mr. Timothy Travis has already answered that question. What we need to do good early intervention, which I think all of us agree would be the first priority in the juvenile system, is we have to have more resources. We don't do it now because we have these older, more dangerous, more involved kids that we have to deal with, we can't ignore. So we need resources to do that. What role can the school play? Well, you know, that is a question that would take a good 8 hours to answer, and it's a long, hard, sad history, at least in this community, of working out a relationship between the schools and the court system, one's perceptions of one's roles and so forth. I don't really have an answer to that. Maybe one of the other panel members would want to try to address it. I don't think I can in the time we have.
Why don't we give Mr. McDonnell that, and I'll give you this one.
My point being is that we have to make the choice, because the reality is there aren't going to be new revenues. We are going to be lucky to retain the revenues that we have, and by not making a choice, we are, in fact, deciding.
If we don't get those revenues, it's not going to do any good. You can throw a half a bucket of water onto a blazing house, and you're not going to put the fire out. So to say that we have to settle for the quote-unquote current economic climate or the current tax climate, that may be true, but if that's true, that's a decision we're making, and we're making the decision to lose. Triaging kids out of the system is not going to solve the problem. But in terms of education, I used to be a public school teacher. I taught junior high, I taught high school. And it wouldn't be difficult for me, it wouldn't have been difficult for me then to point out to you the kids in my class who were at risk. And if we could hook up the schools and the juvenile department, we could intervene and we could do it. All we're lacking is the will.
I'm Paul Milius. I'm a club member. Judge Welch started out saying that the society was awash in drugs and alcohol. We gave up prohibition of alcohol a long time ago. I guess Mr. McDowell may be the person I'd address this to primarily. Do you agree with Jocelyn Elders that we ought to seriously examine removing our 50-year-old attempt at prohibition of at least soft drugs and devote our resources to rehabilitation and education as opposed to punishment?
Well, I will say that at one time I was of the opinion that we should. I no longer, especially after working in the juvenile system, I no longer hold that opinion, especially when you deal with the number of children that we deal that have been born drug affected and see the devastating effects that it has on those individuals, truly innocent people. I don't think that we can follow that course. The outcome or the consequences would be just too severe.
Well, I don't know. I go back and forth on this, candidly. I hear what Mr. McDonnell is saying, and I represent crack babies. I mean, these are my clients, and I know the damage that's done. But I don't think that the current laws that punitively deal with drugs are solving the problem. It's a public health problem. I don't know that I'm ready to say we ought to legalize drugs, but it is a public health problem, and that's where we're going to solve it. We're not going to solve it by throwing people in jail. Let me tell you one artifact of this that's really interesting. Before we started this war on drugs, kids were smoking pot. Now, my clients tell me it's easier to find crack than it is pot, because we have very effectively interdicted the pot growing in the United States. So what we've done is we have, by succeeding on the war of drugs, against drugs, we have made crack more available to children than pot is. If that's a good result, I don't know.
I'm Brad Stanford, City Club member and chair of the Law and Public Safety Committee. I agree with Mr. Travis that taxpayers in this state have abdicated their responsibility for taking care of our children. My question is, let's say we have full resources to deal with the offenders themselves. How do we get at the environments that they come from, which most likely have caused the behavior to begin with?
Sure.
What a wonderful, wouldn't that be a wonderful thing to actually seriously have to figure out? I don't know if we'll ever be at the point where we have that kind of resource level. There are lots of ideas, some of which have been tried either on small scale or even on large scale, including the child, child development specialist in the school systems in Portland that was started back 20 years ago. This was an idea of the early identification of high-risk children when they hit kindergarten, where social services could be brought in. We see these families now in domestic relations, particularly in that area I mentioned of the Family Abuse Prevention Act, young couples, married or unmarried, fighting with their children caught in the middle, where there's extensive drug abuse and domestic violence. There's an opportunity to intervene there. You might have heard that part of my title was of the family court. That's new. We have now this concept of the family court, and we're moving towards some kind of integration, hopefully, of the way in which we deal with families in the court systems. The court's not the answer. The court's not the answer to any of this. The court deals with the failures, is not the source of the solutions. But to the extent that the system itself is a part of the solution, it is early identification, not with a kid who's committed his first assault, but the child who has been neglected, the child who's failure to thrive, the child who is living in a household with parents who are not able to provide that minimum standard. Children still don't have very many rights. They don't have, we have not been willing as a society to intervene and say to parents, this is not good enough. You are not doing enough for this child. We demand more for every child born in this country. We haven't been willing to do that. That's where we would start. And then we'd mean it and we'd follow through. Not in punishing parents, but in providing services and intervention and training and removal if that doesn't work.
I'd like to even go a little bit further in that. I don't think we're going to get out the problem until we can really convince people who are unwilling or unable to care for their children to wait until a time that they can. William Raspberry had an interesting editorial recently. He took 3 factors. One was obtaining a high school diploma and waiting until age 20 until a person is married or has their first child. And they found that only 8% of the people who waited until they obtained their high school degree, are age 20 to have their first child, are becoming married, were in the poverty or below the poverty level. But for those who did not wait for those 3 factors, 79% were below the poverty level. Chicago did a recent, the Chicago Tribune did a recent study on children that were killed in that city, and they had something like nearly 100, I think it was 80 or some. And the most common denominator of all those children who were the victims of homicide was that they were born to teenage, unmarried mothers. Until we deal with that problem, everything else we do is sort of dealing with the fringes or things on the fringes.
And frankly, that statistic about waiting till age 20 to have children is very reassuring, since I waited to the age of 45 to start my family. In a more direct answer to the question about where you'd put the resources, it's not a total solution, but a piece of it is economic. Right now, our children are out there competing with adults for the jobs that kids used to do. If you go into McDonald's today, you'll find out that a surprising number of the people who are working there are adults. My newspaper is delivered to me every morning by an adult. These used to be kid jobs. Kids don't have the economic outlets that they used to have, and it's not the total cause of the crime problem among juveniles. But if more children, especially children from backgrounds where they have very little reason to hope that they're ever going to attain very much, if they had realistic economic options, I think that they would be able to better resist the role models that they see, which lead them to become my clients.
Jim Franciscone, City Club member and a former chair of the State Juvenile Services Commission.
very related questions to you, Mr. McDonnell. I found myself agreeing with everything you said in your speech about too much juvenile crime, the need for more beds at the training school, the need for more intervention at the earlier level. But where I'm confused is on the solutions that you are publicly identified with and the District Attorneys Association is publicly identified with. Why, given those problems, are you not advocating for more bed space at McLaren and more residential facilities in the community instead of automatic remand to the costly adult system? Well, first of all, I have advocated for more resources locally. Secondly, I think we have to face the reality, the fiscal reality that exists in the state. Even the Democratic governor, our gubernatorial candidate, indicates that he's not going to try a new tax proposal if elected. He is going to wait and submit the budget based upon projected revenues. We have a problem that we have to deal with now. And it's a problem that's a threat to our community, and it's a threat to the children who are coming into the system at the very first time.
Yeah, but see, without me arguing with you, sir, what you're in effect saying, as is projected in California, we're going to spend resources we don't have now on the adult system to incarcerate these people, or we're going to have to let out adult offenders.
Well, I
You're
think
dodging the issue, I think.
No, I agree. There's going to have to be adjustment in the adult system, and I agree with that. But the reality is, while the juvenile system was reduced by a third, the adult system was more than doubled. It went from approximately 3,000 beds in 1985 to, I think, 6,500 today or something like that. So it's been more than doubled. There will have to be some adjustment in the adult system, but I think if we're going to make a decision between some adult property offender that's a forger or something of that sort, I think we have to make a decision and lock those people up who are the greatest threat to the community. And we know that the people that are creating these crimes, the greatest percentage of them are between ages 15 and 25. They have the highest rates of recidivism. There tends to be a tremendous drop-off in the rate of recidivism once a person reaches age 25. And I disagree somewhat that there are not resources in the adult system. First of all, under the District Attorney's Office plan, juveniles, if convicted before age 18 in the adult system, can still initially go to the training schools until age 21, provided they're engaged in a treatment program and they're not a disciplinary problem. If they're not engaged in treatment, they're taking up space and somebody else should be using that space. If they're a threat to other individuals in the training school or staff, they need to be incarcerated. There are programs in the adult system. There's vocational training. There's at least a dozen programs. There's 2 apprenticeship programs. There's educational opportunities to obtain high school diplomas, GEDs, and associate's degrees. If people want to turn themselves around in the adult system, they can. As Judge Ellis, I like to quote, says, is that a lot of people think the adult system is a failure, but it's not surprising considering the people that they deal with. These people have been failures in their families, they have been failures in their schools, they've been failures in their communities. And it's not surprising that they're not a productive citizen once they come out of incarceration.
Okay, and so my related question, at the time of downsizing, as you know, there were supposed to be residential facilities built in the communities. And as you also know, in Portland, only Umoja, MyCap, and Yon are the only residential facilities. So when we come to this discussion, why was the District Attorney's Office not there on that issue? And will you advocate on Kulingoski's committee for more of these types of resources in the community?
I have, and I will.
Okay, thank you.
Time for one more question. Let me ask, would you like to come to the microphone?
Is that all right if I ask the last question? I'm Angie Fujioka from the Youth Forum, and I was wondering what exactly specifically the people in this room could do to help with this problem that's very large and involves the whole community, and to what degree should they feel responsible for the problems that a lot of these children have?
I can tell you two specific things that you can do. First of all is the old saw, get involved politically. The second is volunteer to be a CASA. CASAs are court-appointed special advocates who work with dependent children, abused and neglected children in the court system. And as I've said before, these are the children who grow up to be the delinquents. If you can make a difference in the life of a child, you can make a difference in the life of a child by being a CASA.
I think what you can do is adopt Mr. Travis's quote from H.L. Mencken, simple solutions. Nobody's mentioned 3 strikes, you're out today. This is the ultimate simple-minded solution to an extremely complicated problem. And I don't want anybody to misinterpret my statements to say that I think that people who have committed violent crimes ought to be allowed to walk the streets. But the idea that incarcerating children and adults is going to solve any of these problems it can only be made by people who have never read anything and who don't know anything about the statistics of either of these systems. They're not simple solutions, aren't any good.
Well, we'd like to thank the panel. On behalf of the members of the club, I want to thank all 3 of you for bringing your expertise and your passion to us today. We're adjourned.